very warm welcome to our external guests. I see a couple of them, a very warm welcome as well. Indeed, to this final lecture in our course on Chinese law. And I would say we have saved the best for last. Right, so far we've been dealing with hard law, positive law matters, studied different fields of Chinese law. And today, basically, we switch more to the policy side of things, yet we keep it legal because Dr. Adam, who's with us here today, will talk about the EU-China legal affairs dialogue and legal affairs cooperation in general. And it actually will nicely build on yesterday's lecture as well, because she's also told me that she will also be talking about human rights dialogue. And of course, yesterday we've had the introduction to China and international human rights law. So this should nicely build on that. Dr. Adam is joining us from the European External Action Service, and they are in the midst of the preparation of the next summit, EU-China summit, and the legal affairs dialogue in that context. So she's really the person to talk to you about that topic. And she has promised me to introduce herself. So my job is already done here, and I thank you very much for accepting our invitation in this very busy time for you, and a very warm welcome to Leuven.
Yeah, Marta, thank you so much. Welcome, everybody. Good morning. Yes, my name is Irmgard Adam. I work with the China division at the European External Action Service. I joined there in October. But I come from Germany, from the Foreign Ministry, and I have been working there for quite a long time. I just said I joined in 1980, and I was posted in Beijing from 81 to 84, right at the beginning of the modernization policy. So it was a very interesting time to live in Beijing. I studied there at the university and then worked at the embassy. And then I went back to Bonn, which was still the place of our government at that time. And then my CV is a little bit unusual because I interrupted my work and I started my family. I have 4 children and I didn't work for 20 years. So when my children grew up, not as old as you are, but a little bit before, I got a phone call from the Foreign Ministry whether I wouldn't like to start again and work. So I thought, wow, this is really great and fantastic. And so I did quite a few postings within the Foreign Ministry in the Human Resources department. I worked with the Minister of State, Dr. Klaus von Donani. I worked in the law division, responsible for international law and the International Criminal Court. I worked for human resources in EU and international organizations. So you see, the idea of the work within the Foreign Ministry is you do everything, and you should develop some kind of capacity to deal with matters in a diplomatic way. So that is the main accent. You have to develop your capacity to deal well with a lot of people and situations, and to understand rather broadly the situation than dig deeply into one subject. And then I was posted again to Beijing in 2013 and worked in the press section. First time I worked in the political section, and I came back in 2016. And then worked in the India division, responsible for economic relations and development. And in between all those years, I was shortly also a part-time lecturer at Free University of Berlin. So that's a little bit my very unusual background. I'm very happy to be now with EEAS because the perspective on China is really different than the bilateral perspective you take when you work with a foreign ministry within a certain state. Because here in Brussels, you deal with China and all the interests of the 28 member states come in. And you have to consider all the different interests of the 28 member states. And we feel that very strongly, especially now when we prepare the upcoming EU-China summit on 9 April. You have to consider what member states want and what member states need. And there's a lot of more complex coordination and talking to much more stakeholders than I'm used to within the foreign ministry. Right. But now let's enter a little bit our subject today. I want to talk to you on EU-China legal affairs. Marta, do you have something to? Okay. I would like to introduce you a little bit to the overall architecture of EU-China bilateral relations. And then I want to come to legal affairs and talk on the legal affairs dialogue, but also a little bit on human rights. And I learned that you have already some background on human rights and China. So let's see how it works together. So what are the guiding documents for EU-China relations? You have the EU-China 2020 strategy for cooperation, which has been agreed on in 2013. And that is the highest level joint document guiding EU-China relations. And I copied an extract of that document here for you. And it says, EU and China commit to enhancing dialogue and coordination at a bilateral, regional and global levels. They want to deepen exchanges on human rights at the bilateral and international level on the basis of equality and mutual respect. They also want to strengthen the human rights dialogue with constructive discussions on jointly agreed key priority areas. That's what you can read in the document from 2013. And if you think of our thematic discussion for today, there is no mentioning of legal affairs. And we will come to that later. Of course, the EU and China have their own strategic documents respectively. So in 2016, the EU adopted a strategy on China, and China has issued policy papers on the European Union, and the latest is from December 2018. I think it's the third. So these two papers give additional insight into how the relations between the EU and China should be developed. The dialogue and the overall relations can be described as relying on three pillars. And you see, you have a political pillar, which is there on the left side. Then you have a second pillar with economic and sectoral dialogues. And then you have a third pillar, people-to-people dialogue. So the political pillar is very important with the political dialogue and the high-level strategic dialogue, and quite a range of further dialogues. And it is, or it should be, a habit to have these dialogues taking place before the EU-China summit. So they take place in a regularly rhythm. Sometimes there are time restraints, or maybe government reshufflement or things like that. So the rhythm is not really very fixed, but the idea is to have it very, very regularly and very, very continuously. And if you see, look in the political section, there should be also the human rights dialogue. People to people, yeah. And again, this is a card from 2015. And again, you don't find the legal affairs dialogue. So that is very interesting. The sectoral and economic dialogues involve very much all the commissions, EU commissions. So, for example, if you have an urbanization dialogue, it would be DG Regio or DG Move, whatever is exactly done in this dialogue. And there are constantly new dialogues approved. So overall, we have more than 60 dialogues in this kind of format. And it keeps really the whole commission busy, and the Chinese side, of course, too. And then we have the third pillar, the people-to-people dialogue, and that was a very pleasant dialogue. For example, last year in Xi'an, it was there was an end event saying that this people-to-people dialogue was very effective and very helpful for bilateral relations, and it includes society. So you see, we try to have all levels of engagement and as broad as possible, because the broader, the better the contact with China can be established. So now, what exactly about the legal affairs dialogue? Only in 2015, at the EU-China summit, there was a joint statement saying that EU and China want to set up a legal affairs dialogue. And the idea is to create a venue to better understand the respective legal systems. And I think that was very important, because you, after your lectures in this course, you understood how different the legal systems are, and how important it is to have a basic and deepened understanding what the other side is doing. So the idea is to deepen partnership in a wide range of areas in the legal domain. And you already also saw the EU was late in doing so. The legal affairs dialogue has been agreed upon much later than, for example, the US did, or Germany. Germany established its dialogue already in 1999. And the EU and China had to discuss a lot how to distinguish the new dialogue and separate it from the existing human rights dialogue. So for a long time, EU wanted to establish it, and China was a little bit reluctant. So then finally there was an agreement that the new dialogue should not have any direct impact on the substance of the EU-China human rights dialogue, and that it should be much broader and cover much more issues and be really totally separate from the human rights dialogue. So that's the reason why in 2013 in the joint document and in the card I showed you from 2015, the legal affairs dialogue is not yet mentioned. And one difficulty was how to name the dialogue, because obviously it had been, the human rights dialogue before had been a sensitive issue, especially for the Chinese side all the years. And the Chinese side wanted to avoid these difficulties, and the EU, of course, also. So they called it the legal affairs dialogue. And if you look at Germany, for example, Germany's bilateral dialogue is called Rechtsstaatdialog, rule of law dialogue. So the idea behind is different. And it shows that the EU-China legal affairs dialogue is a much more technical dialogue, a very open dialogue. And the idea is to exchange information rather than to get a certain result. So what kind of information would you like to exchange? There's a huge range of possibilities, but so far it has been legal topics of mutual interest, very actual legal topics, and I will show you how the dialogue evolved. So after the joint summit statement, the first legal affairs dialogue took place in Beijing. It was in June 2016. And the topics of discussions were e-commerce and consumer protection. That dialogue consisted of two parts. It was a high-level segment where leaders from both sides met. And besides that, there was a technical section, a workshop, where experts and members from the relevant ministries and commissions met to exchange information on e-commerce and consumer protection. So in that year, there was an agreement to have the legal affairs dialogue every year. And the next dialogue was therefore in Brussels in October 2017. And the Chinese delegation came, and they wanted also to have a study tour to Paris. And they were received by the National Assembly there and had some additional information on European law system, French law system. So this time you had quite a wide range of topics for discussion. It was better regulation. It was improvement of the quality lawmaking. It was transparency was a big issue, how to create transparency within law, and how to involve the stakeholders. And it was also on evidence-based policymaking and uniform implementation of laws, which is a topic for China and the EU because of their big entity already. And I think from Professor Chen Lei, you also know that uniformity of law within China is quite a topic for the Chinese, and harmonization of law is quite a topic also for EU. So this is something where exchange can be helpful. And then the making and the development of the Chinese Civil Code was also a topic of the second legal affairs dialogue. China, you heard already, China has been establishing its legal system only since 1978. And it has never had a legal civil code in this modern style before. It comes from the socialist tradition, and the own cultural tradition is also very different from every Western civil code. So this is quite an experiment. And for Europeans, it is very interesting to see how China tries to incorporate tradition into its civil code and to manage transformation to a new society, and also how to manage transition from the socialist era. And this making of the civil code is of big interest also for EU. So we decided and asked the Chinese side if they could include a new information session for the upcoming legal affairs dialogue in 3 weeks in March in Beijing again. And I think they will have some quite new developments to tell us on property rights and law, land law, and quite some other areas. I think the Chinese can better explain than I can. And this legal affair dialogue will again be with 2 parts. It will be a high-level segment where the leaders meet, and it will also be again a workshop. We have quite a number of experts from the relevant ministries, from the Commission and from the Chinese Ministry of Justice, and we will also have experts from the business area and from university, from research. So we will exchange quite a number of topics. It is still in preparation, so I think middle of March you can look in the press. There will be more information on this. But so far, this legal affairs dialogue has been very successful. It is a very technical dialogue. It is really a forum where you can exchange different views and different approaches to law. And this so far has already helped a lot to understand the other side and to better understand ongoing developments. So you can really say the legal affairs dialogue is an important bridge and between EU and China. I said there are many areas you can discuss in the bilateral, multilateral, and domestic level. So far, it has rather been the economic side, which is, of course, for exchange also very important, and the better you understand it is helpful. And you can also see now that there are new developments worldwide which are of interest for the legal affairs dialogue. These new developments, such as artificial intelligence, for example, they create new legal problems to be solved, and that is a very interesting area to discuss as well. Especially in artificial intelligence, it's not just a topic where you have to think how to solve legal problems, to identify whether there are legal problems. For example, if you have electronic mechanisms, who is responsible if something happens in the internet? Can it be the electronic system, or who else? Should it be a person? Things like that have to be discussed and solved on the Chinese side, on EU side, worldwide. But these developments also have a strong impact on human rights, democracy, and the rule of law. So that is also a very interesting area to discuss with the Chinese side. How do you approach these new problems? How does the EU approach these new problems, and what solutions are found? And then, of course, within China, there are some interesting developments also. China's economy is growing. There's the Belt and Road Initiative, and the initiative needs, of course, very good conflict-solving mechanisms too. So China at the moment feels that there is a need to expand the existing instruments, and it's discussing a lot on alternative dispute resolution mechanisms. There are internet courts being built up. Professor Chen Lei told you a little on that already. There are commercial courts blooming. Chinese are very much experimenting with big data and the use of big data within courts. And that is also very interesting for us to see. Is it possible to use big data, for example, to say in advance whether a person could be criminal or not? So big data not only describing the behavior of a person, but also being able to predict if a person could be criminal or not. So this use of big data and the ethic questions behind the approach is obviously very different between China and EU. And it is interesting to see how far China can get, let's say, on the use of big data in the medical side, medical imagery. China is very strong on that. China is also using big data to bring order into its society. From the development since '78 has been strongly characterized by urbanization, very, very fast urbanization, and this means the society is almost overwhelmed by the development, and there are a lot of societal problems, especially within the towns. So China is trying to steer that through the use of big data rather than engaging more police, human resources. So that's an interesting development. It has some positive sides, and when you read in the newspapers here in Europe, you rather read on the negative impact of these developments. So today I wanted to open your mind a little more on the two sides of this development. Every coin has two sides, and that there is a reason behind why China uses so much big data and technical equipment to steer the society and to guarantee that society is stable. On the other side, you also read maybe in the newspapers this year for Spring Festival, there were billions of people traveling, but there were also quite a range of people who did not get a train ticket because of their bad behavior in society. So there's this punishment, and that's exactly the moment where discussions start with the Western countries. There's also a structural difference. Basic structural difference we have to take into account. China and EU are not only very different political entities, but they also have very different approaches to law. I put the two pictures for you. So you can see China is a national state, a unified state, with laws governing China mainland overall. But you also learned in this course, I think, that there is this hukou system, which means that especially for land law, there are two systems. And this structural divide can mean that certain laws can impede the nationwide validity of other laws. So there are conflicts created. And China has to struggle a lot to manage this and to develop this. Another area is social security law, which has been much faster developed in the coastal areas, while in the country areas, China still relies on the structures of the family, and the social security system has been developed only much later, years later. So there's a big gap of development, and these problems are not only seen, but China tries to harmonize these structures, though there are still many, many problems to do that. And on the other side, you have the EU, which is not a nation state, but has developed quite a range of institutions like a nation state. It has a parliament, it has a council, it has a court system, but you still have 28, up to now, 28 member states. And these 28 member states are individual member states, and it is quite a challenge to harmonize the voice of the 28 member states, especially when it comes to China. And you see from the flags, you have the traditional Western European countries, and then you have the countries, the Eastern countries, who joined the EU much later. And they have also different stage of development, different needs of investment, and so on. And China is very attentive to these basic situations. For example, it started the 16+1 format to stronger engage with the Eastern European countries. And this is quite something where we observe on the political field that it is not a divisive thing. China can, of course, in this format engage bilaterally with each state, but it should not be a regional or sub-regional format dividing EU. Then EU would strongly oppose to a format like that. So you see, we have, on the political side, we have to see all these developments. We also have to see that China is very differently engaging with the countries as far as concerned investment or infrastructure, things like that. So you cannot deal with China on the basis of one size fits all. China is a cooperative partner, for example, in the international field. When it comes to climate change, we have common goals we try to push ahead. China is a competitor in many fields of new technology involvement, and even sometimes a rival. So we have to see how to approach the different situations. I would like to continue a little and talk on human rights dialogue. I told you that the human rights dialogue is really completely separate from the legal affairs dialogue, and it's much older. And in principle, EU and China have an annual human rights dialogue. And the 36th round of the EU-China human rights dialogue was last year in Beijing in July. And the number 36 EU-China human rights dialogue shows you it's quite an intensive dialogue in principle. And I put together for you 3 pillars of this last human rights dialogue, which is something like a repetitive thing going through all the human rights dialogues. For example, EU recalled that China has not yet ratified the International Covenant of Civil and Political Rights. China has signed it, but it has not ratified it. And this is something you would like to see China to do, and to complement its engagement in the field of human rights. So that's on the treaties level. And then EU usually raises a number of individual cases and is addressing these individual cases according to the special situation. Very often it's the request to release a certain person, to have access to the person, to give a EU member state access so that consular work can be done. And it is a very subtle and very sensitive policy area. So there is a lot of discussion in advance on every single case, how to approach this, on which level, how intensively, when, in which format. With the aim not to help that person, but not to worsen a single person's situation. I'm mentioning here the case of Gui Minhai, because later on I have a small reading list prepared for you, and there's an article on Gui Minhai. Gui Minhai, I don't know if you heard about this case. He's a Swedish national, but he was born in China, so originally he was Chinese. And he was traveling in China accompanied by 2 Swedish diplomats, and he was captured by the Chinese police, and since then he's in detention. So it's not only Sweden working for his release, but because Sweden is also close with EU, it is also a European case, and the EU has engaged for Gui Minhai. I don't want to enter too much into the details, but when you read the article, you can see that there are also legal implications, and that there is much discussion, among other, on the Vienna Convention and on this question of double nationality, how to treat this question of double nationality. In the press, you can see that there was a discussion. Gui Minhai said, "Oh, I don't want consular assistance because I'm a Chinese national." And then everybody was wondering, but he has changed his nationality. He's a Swedish now. So the question is, did he give up his nationality? Did he not give up his nationality? Has China a right to still consider him as a Chinese national? What does the Vienna Convention say about this case? Is it silent or is it not? I want to make you a little curious and not tell much more, so you could read a little and get more insight from this article. My point here is these single cases are not only political cases, but legal cases, and there are many more other aspects involved. And it's also a question how to steer it. Would you rather solve it on the political level, or can you solve it through other channels of thinking? So human rights discussion with China is really, really broad and very diverse. And then through the human rights dialogue, there's a third section, and that's more the systemic problems we see with China. So the EU raised the issue of the death penalty and systemic problems in the criminal justice system. I think Professor Chen Lei has introduced you a little bit to that. And there is this administrative structures, arbitrary detention, and the restrictions on freedom of expression and association. So these are the things EU tries to address: systemic issues, individual cases, and the international law agreements. So what about EU human rights? The EU issues an annual report every year on human rights and democratization. And there is a debate in the European Parliament on human rights and democracy in the world overall. And there is also debate on how the European Union should deal with this matter and which policy to develop. And besides that, the EU has an instrument to start external action. And there's an instrument specially provided for external action in non-EU countries, which is called the European Instrument for Democracy and Human Rights. And this is really a thematic funding instrument, especially in the area of human rights, fundamental freedoms, and democracy. And it's an instrument for civil society engagement. So the idea behind is that civil society should support the idea of human rights and engage on the ground on certain projects and defend human rights and develop human rights. So if you look at the webpage of this instrument, you can see what they do precisely, and there are also calls for action, and you can see what are the specific topics in a specific time. Besides these European Parliament discussions and the instruments we have, every year there is a Council conclusion on EU priorities in human rights fora. And the latest Council conclusion was just now in February. And I extracted some parts of this Council conclusions for you, because you can see the engagement within the European Council fora trickles somehow down to engagement with China. So first of all, there is this basic commitment that the European Union will continue to denounce human rights violations and abuses wherever they are committed, and that it will use all available tools and fora to fulfill its commitments to human rights and to promote human rights globally. So they also say where EU wants to do it. So it's in the framework of the United Nations Human Rights Council, in the General Assembly of the United Nations, also in the Security Council and other relevant fora. And if you watch the press, there's now a discussion ongoing on the Universal Periodic Review, and you should look the next days what the press will say on China, if there will be item 4 something or not. So EU is strongly engaged in these fora, but there are also quite a wide range of other ways to engage for human rights. So EU is constantly issuing public statements. It's starting diplomatic démarches. It's engaging in diplomacy. It's engaging in human rights and political dialogues, and that is part of the overall structure I showed you. We have the human rights dialogue, we have the legal affairs dialogue, we have the high-level political dialogues, including the strategic dialogue. Then, of course, there's this universal periodic review within the Human Rights Council. And EU also engages with UN special procedures and sanctions. So again, here it is a very case-to-case assessment, and EU never works just alone at EU level, but there is always a very intense discussion at member states level. So for example, when you have an individual case, the EU delegation in Beijing is working together with the relevant colleagues of the EU embassies in Beijing, and they sit together at very regular meetings discussing each individual case and deciding on the action to be taken. So this is really very work intensive and very attentive, and there is a very careful evaluation on which level to take action, or even sometimes better not to take action, so that the life of a certain person is not endangered. And this demands a lot of sensitive engagement, and it's good EU can discuss it with member states and have groups to discuss, because the bigger the group, the better you can exchange and find a good way how to approach a certain problem. The EU, as I just said, it's building coalitions with member states, but also in a broader context. And it's on thematic issues such as death penalty, for example. And it's also on country situations. So this approach describes the situation worldwide. And the Council conclusions also say that the European Union seeks dialogue on human rights with all states. Should be no exception. So that all human rights can be realized worldwide. And the European Union repeated again that there's no hierarchy of human rights. So there's a strong and unequivocal opposition to the death penalty in all times and in all circumstances. So if there is a death penalty issued by a Chinese court, EU would in any case say that it opposes to death penalty, and say that very clearly and very publicly. So death penalty is really something where the EU says this should not happen. And the EU also inserted a passage on China in the Council conclusions, and it reads, the EU remains seriously concerned about the reported cases of mistreatment and torture under detention in China, and calls on the authority to thoroughly investigate them. So this is addressing some of the systemic problems. Besides that, EU has been very active recently also on the situation in Xinjiang. There has been urgency debate in Parliament at the end of last year. There was the possibility for some EU officials to visit Xinjiang and get an impression about the situation in Xinjiang. It was on invitation by the Chinese side. Of course, it was a guided tour, so we were very grateful this tour could be undertaken, although it was not something where EU officials could freely walk and talk to people and get their own picture. So there are many, many fields to engage for EU, and China doesn't like to be reproached too much. So in the press you can also see strong rejections by China on single cases. It's very interesting to see also. So it's not a one-sided thing, and it's two parties dealing, two countries or two big entities dealing with each other. So overall, I think you are already you heard about that. In a way, China has accepted the universality of human rights with its support to the resolution to establish the Human Rights Council in 2006. You remember the Human Rights Council has been established because the older structures have been deemed inappropriate and inefficient. So there was this undertaking to establish the Human Rights Council with a universal periodic review. And China has supported it, which has been interpreted as China really supporting the universality of human rights. China also signed a wide range of human rights treaties. I'm not going to introduce you in detail to that. I heard you had some introduction already. China signed and ratified quite a wide range of human rights treaties, also here and then doing making exceptions on certain clauses. And in 2004, there was an important development on the national level of law. There were changes in the constitutions which refer also to human rights. There was this, for example, guarantee of private property, which was a very important development for the people inside the country. So I introduced you to the European thinking and way of behaving when it comes to human rights. But what is China's notion? And you will hear immediately that China's notion of human rights is very much different to the notion we have. China views human rights in strongly aspirational rather than legal terms. So that means socio-economic rights and the right to development has big priority over other human rights, and the EU says there is no hierarchy of human rights. That's a difference in approach already. And China also says that human rights are goals to be attained on the path of development, and they are not a binding legal obligation. So European thinking is that every human has human rights from the moment he's born, and you cannot take them away. Very simple saying. And for China, it is rather kind of development, and the better developed the country is, the better human rights are. So individual rights are always lower than, and political rights also are always lower than socio-economic rights. And when you discuss a certain problem within human rights, you should never forget this different approach. And in this context, it's also very important to know that China thinks that maintaining public order is a prerequisite to realize human rights. It's a precondition, and without stability, nothing will work. So, as a result, it can happen that fundamental rights of dissidents don't have the priority as we think they should have, because there are other priorities that impede realization of, let's say, for example, fundamental rights of dissidents. And now I want to come to some examples. I don't want to concentrate on criminal law. I don't want to concentrate on the international sphere, but I want to concentrate on human rights in China and open a bit your eyes to the problems around realizing human rights within mainland China. So one very important topic is women's rights in China. And now I just see a sign, Marta suggested we have a little break. I don't know, Marta, how much, 10 minutes, something like that. So before we come into details, let's have a little break, because I have something to do right now. And we'll meet again in about 10 minutes' time, and we come to the details of human rights within China. Thank you so much. Yeah, so we are back to class for the second half. And I want to introduce you to human rights in China and some of the problems behind it. I want to open a bit, don't want to dig into one special thematic area, but I want to open you a little bit your view on how many issues are connected with realizing human rights and what it means, especially in China. So, and I don't want to talk on criminal cases. I think you have some little background already on that through Professor Chen Lei. I want to focus on two issues, and one is women's rights in China, and then I want to focus on children's rights and the issue of China's left behind children, or how you say black children, 黑孩子. Let's see what it comes out. So on the international level, China was very active on individual rights in the 90s, and they had a big women's rights fora in 1995. And China signed and ratified, which is important, the Convention on the Elimination of All Forms of Discrimination Against Women in 1980 already. So that is an important thing. And it is also connected to the start of the modernization policy. You remember China ended with the socialist era, but it still stood very strongly on its own cultural roots, where the family plays a strong role in everybody's life. And family structures in China mean that the individual has for many centuries been embedded in the family. And the family was an economic and social unit. So it was the family who provided all the care of the individual and provided also the means of subsistence. And the head of the family was responsible to guarantee that the family could live well. And of course, the family lived in the extended family and clan structures. So it was, in the end, it was the family who paid for social security, for education, decided on the economic structures. And that is very different to what happened in 1978 with the start of developing private law, which means that every law relation depends on the individual. So in a way, it was not only the socialist structures rejected, but it was also family structures rejected. But at the same time, the development approach, the modernization approach, was somehow double-layered because of the hukou system. And in the rural areas, the land to cultivate food, to grow food, was given to the family and not to the individual. So they counted, let's see, father, mother, children, and maybe grandparents or parents in the family. So they counted how many people are there in the family. One piece of land for each person on the basis of equality. So they looked, you get in the village, you get the share of the good land, and you also get the share of the bad land, and it was distributed, it was allocated. So this means the children, especially the women, are strongly embedded in the family structures and with that also in traditional patriarchal structures. But now, since the start of modernization policy and reform policy, national laws say every person has equal rights. And this is true for men and women alike. And if you look into the Constitution, this principle is clearly enshrined in the clauses, but it is also enshrined in the single laws, such as the marriage law, the inheritance law, the land law, the law for the rights of the women, and so on and so on. And it is repeated many times. And it's repeated so many times that you think, oh, is there a problem maybe behind? And I want to introduce you that there are political priorities, legal inconsistencies, and structural questions behind. And they can, in certain cases, undermine the new idea that everybody, men and women, are equal. When I say so, you have to remember that the approach to the law system is different from our approach here in Europe. When you say everybody is equal, it means on the relation between civil society. It does not mean equality in relation to the party. And when you look into the Constitution, you clearly see in the preamble there is the guiding role of the Communist Party, enshrined. And if you look further down in the Constitution and also, for example, in the land laws, you find that there's also a hierarchy when it comes to access to resources. Land was a very important issue to modernization and reform. It had been socialized so far, now it was given back to the people, but just for use, and ownership rights stayed with the Communist Party, with the state. And there is also a double layer, land laws for the coastal regions, for the urban regions, divided by the hukou. That's a different law regime than for the rural people. They use land under different conditions. And if you look, there's a hierarchy. The state has the monopoly on law and on land. Then there is urban land use rights, and then there's rural land use rights. So rural people always have the least opportunities in the use of land, and that is still so today, although they try to change the situation and harmonize things, but there's still a lot of work to do. So when it comes to rights in China, you always have to be aware when you read a single law, let's say marriage law, where it says, or inheritance law, everybody is equal. It is on the basis of relation of everyday people, but there are some overall structures around which are very different from the structures we know here in Europe. So you have this overall idea, women's rights are equal to men's rights, but there's a problem when it gets to the right of inheritance and access to property. And this is clearly a conflict with tradition. I just explained to you the family system means that the family lives as a social and economic unit. and decisions are taken either by the head of the family or within the family overall. And now it should be the general idea is that women have individual property rights. But in the rural areas, under the specific land system, land is given to the family. So what happens to the women's rights? For example, when the woman wants to marry and she would leave her family and join the husband's family, this kind of behavior is still very common, especially in the rural areas. So it would be, under the new system, it would be a very simple idea to say, okay, then she takes her land rights with her into the next village or next family, and she uses it there. And if she cannot, wrap her piece of land and take it along with her, she would sell it or make some economic use out of it, so to restart in her new place of living. But there are problems with it. It's not only the head of the family or the family overall that would very easily object to this idea because it's against traditional behavior. So the father of the family would say, "Oh, you simply cannot take away your piece of land. It's not the way we should do it." And then the woman is very easily stuck because the piece of land is allotted to the family and it's not registered individually. Behind this question of registering, there are wider problems. The huge rural areas have never been, the land of the rural areas has never been registered in a very systematic way. And it has been registered only, I think, to a village level and not below. So there are many problems for a woman to solve how to take with her the right to land. And the right to land is the most precious property right a woman has, especially in the rural areas. China is trying to establish a cadastre system which has worked rather well in urban areas. There's still a lot to do in the rural areas, and especially there's a lot to do on village level, and then especially on family level. And if you allot a piece of land to a family, why should you register individual pieces of land? That's even much more work. It's cost intensive, and from that side also really hard to realize. And nevertheless, there are strong efforts to build up a nationwide cadastre system, and this is strongly pushed by the need to have this small family plots of land organized in greater systems, so to do a modern agriculture, use of machines, and so on. This is one thing where the woman, because of the structures and traditional thinking, is very often left out when it comes to realization of her property rights. And the other issue that often affects women's rights is women's rights to inheritance. And if you look into the inheritance law, again, you find as guiding principle men's and women's rights to inheritance is equal. And that's a national law. It should be for all citizens in mainland China. So you think, oh, that's very easy and very easy to understand also, even for a European. And then you look at reality and you find, oh, it's not what is can be seen in reality. And if you read the law a little further down, you see some clauses saying that if all parties agree, they can distribute the land differently. If all parties agree, they can distribute the land differently. So just imagine in the rural areas, somebody within the family dies, and his piece of land has to be transferred to the next generation. And everybody agrees under a patriarchal system. It could be very easy for the patriarch of the family to decide how the land should be distributed. And the woman who has a minor position in traditional China is left out. Because there are other structures, the son has to take care of the aging parents, and the woman would marry to another family. That's the traditional thinking. And the inheritance patterns behind are according to this traditional thinking. So that's another area where the rights of a woman very often just cannot be realized. And it's very difficult for a woman to stand up against that and to defend her own property rights. So now I have a very interesting question to you. EU has been trying to harmonize private law as well, and it has been harmonizing inheritance law. And does anybody of you have an idea how this was done? Just imagine you have 28 member states so far. And the approach to inheritance law, of course, is not the same in each member state. So what is very often in European countries the guiding principle when it comes to inheritance? You see it not within the national view, but overall European law. So the guiding principle usually is that a national from country X, when he dies, the laws of this country apply. And very often it is then clear for the parties how to distribute the laws, the shares, and so on. But it's connected to the idea of which nationality does the person have. And now the EU said we need to have a harmonized inheritance law, and it should be for all EU citizens. And the idea was, we don't connect it to the nationality, but to the place of living. So, for example, when you come from Spain, you have a Spanish nationality, and you live in Brussels, and something happens to you, and you die in Brussels. Under the new law, it would be Belgium law to be applied. And maybe your family would say, what is this? She is my daughter or my relative. She's a Spanish. She has always been a Spanish. Why should we apply Belgian law? We don't even know it. Big confusion. So EU also has some clauses saying that if there is a strong connection still to the country of origin, or if the person who died has explicitly said that his original law system should be applied in case of inheritance, you can do so. So you have a solution which is in a way very similar to the Chinese, to the solution the Chinese found. And it's under the special circumstances, you have a guiding principle, but you have a possibility to solve the issue in the individual case otherwise, because the daily structures just need to have these structures so that people can live in peace and harmony with each other. And I think this example is very interesting because there are two entities, a nation, China, and a European Union with member states growing together, trying to harmonize things in Europe, trying to develop and modernize a nation in China with structures and solutions that can be, in a way, compared. The other example I want to introduce to you is children's rights in China, especially children's left behind children, Heihaide. Anybody knows why they are called Heihaide, black children? And again, you should look into marriage law. Marriage law, it's called marriage law, but in a way it's a family law codification. There is an article saying that children, no matter whether they are born within a family or stepchildren or adopted children or whatever, they all have the same rights. So what about children's left behind children? From the legal perspective, they have the same rights. But what is different with these children? The China's left behind children, Heihaide, are called black children because that are the children born under the one-child policy, but outside the plan. So very often it is the second child or even the third. And for the parents, when they had come into this situation, they knew they would have to pay big fines to have this child. So very often they did not register the child to evade this fine. But the legal consequence is that these children, from the legal perspective, do not exist. They are never registered, they do not exist. So when you count your population, you better do not rely on registration. Or on what do you rely? I don't know. So you had these children, and when they are small, it really doesn't matter so much. But when they come to school, it is getting a big problem. And because then for enrolling school, you have to present your hukou. And hukou means the child is registered. And if you can't do it, you have a big problem, and the child cannot go to school, neither in the urban areas nor in the rural areas. So this is a big disadvantage for the children. And there have been many projects from abroad trying to change the thinking of the people. Please register your child. It is important for its future life and things like that. But under the one-child policy, there was many parents were really afraid they cannot pay these big fines, and they did not register. And the situation got better only when the one-child policy was given up and the two-child policy was started. And along with the two-child policy, the Chinese state said, now we also have to register the Heihaide, the left-behind children, and give them a legal existence. So you could think now it's easy for the parents. They just go and go to school and say, well, under the child policy now, I get my hukou and I enroll my child. But very often, under the one-child policy, parents had some kind of silent agreement with the authorities that the authorities would not further detect a special family situation, and the family paid for that. So then if they want to go now to register under the hukou system, there is some intermingling and discussing, but you paid for that and you are out, you are not a black child anymore. So it's still very difficult to register and the hukou system out of very factual arrangements they found within daily life. And it's still very difficult to enroll at school, but still the basic idea is black children should be registered, and once they are registered, they can go to school and they can have medical assistance and build up their own life. I found some example in the internet which reflects very well the thinking of people in China. Somebody asked the question, can a black child leave China? If it is not registered, if it has no legal existence, how does it get a passport? Can it leave China? So the answer is, in China, when you talk to right, you first need to talk duty. What do these children's parents do for China? Do they pay the tax? Do they join any volunteer job? Or do they even try to obey Chinese law? No. They don't register their child, and they do many other things as well. So why should we give these people and the child of these people Chinese civil rights? Do not say they are pathetic and helpless. They are more pathetic and helpless Chinese children who do not have clean water, electricity, and basic education. So I think this example from very daily Chinese life in a very simple internet page somehow illustrates the thinking and the arguments behind. And you're from the mistakes in this page, language mistakes, you also see it's a very simple page, but somehow very illustrative and good example. So when it comes to human rights in China, there are many obstacles, inconsistencies within the legal system, structural problems, political priorities, and the way these elements work together are different than in Europe, and they lead to different results. What about the international level? I said I want to just to say a few words on the different fields, not dig too deeply into each different field. But what about the international level? China is getting more and more active in the international field, and especially in the economic field, and activities all over the world are intensifying. Very often these activities are undermining the international human rights agenda. For example, in Africa, now with getting the resources for electric batteries, there are big discussions. So this is observed by the international community, And you should know at the same moment, China has always said that its international engagement is done under the principle of non-interference in the internal affairs of other countries. So there is some tension with the international community's idea of human rights agenda. And there's a very interesting development also now with China getting economically stronger. China is investing in a lot of countries and engaging economically. So when there is a political change in these countries, it can also mean that economic investment is endangered. It's a very interesting case now in Venezuela. And I think China invested, and they have agreed with Venezuela that the payment would be done in oil. But now the oil production is stagnating, so it's not a very comfortable situation for China. So it's not just human rights agenda, but it's also general political principles such as the non-interference principle. Can it at some point be compromised by political developments? And how will China react, and how will China protect its economic needs worldwide? And what kind of foreign policy is China going to shape? So this is a very general remark, but just to open human rights, policy, law, there's a strong interaction between these fields, not only in the domestic field, but also in the regional and in the international field. I gave you some examples. And this is my talking to you today. I have some internet links for you. There's a fact sheet in the internet on EU-China relations with a lot of further links, including links to the documents I introduced you at the beginning of our talk today. And I also offer you here the link for the China policy paper on the European Union. It has been issued in December, 13th of December, so it's a very new thing. And I also offer you here the link to the speech of Commissioner Jourova on the EU-China Legal Affairs Dialogue, where she outlines a bit the European view on the legal affairs dialogue and what China and EU have agreed to do there. Earlier today, I also referred to this Gui Minhai case and China's approach to international law. This is also a piece of reading just to give you better overview of how many questions can be involved when you have human rights and legal affairs to talk about. And I also added a text, a very critical text, and the EU approach and assessment on human rights. A very critical text, also not with the idea to present it as an opinion, but to open a bit your mind and your view on things, and maybe to start discussion among you and get your own picture and opinion on what is going on. So thank you very much. If you have any questions, I think we have a few minutes left. Just go ahead. and I will try my best to answer you. And yeah, very good. I think you have to see it also from the development perspective. Human rights issue started around Tiananmen, where EU and other countries strongly objected to China reacting to protests within the people among the people in such a way. And there was not only this ban on military equipment export, it was also the moment where they started to stronger discuss human rights issues. And it has started in a way that is rather confrontive and reproaching. You should not do the way you do, in a very simple way, with some best intentions behind. But I mean, from the psychological point of view, if you reproach somebody, the other side has the feeling it has to defend. And that's in a way happened with the human rights dialogue, not only with the EU, but also with many other countries. And China has taken different strategies to react to that. From taking low level, low key, trying not to make things worse, and trying to work behind the scenes, influence outcomes of discussions at the international level. And with growing economic and political importance, there's also more assertiveness and less willingness to talk on human rights the way it has been done up to now. So it is, maybe if you read in the press, it is always a big thing to agree on a date for the next human rights dialogue, not only for EU but also for other countries. And the Chinese would say, if the counterpart behaves well in Human Rights Council and on item 4 things and questions like these, then we can maybe have a human rights dialogue. So it's on this level they interact, but so far I don't see that there has been a very strong and stringent economic sanction or political sanction. There has always been these peaks about leaders from Tibet and so, but after a while things have also been settled. And I think it's a very interesting thing to see how it will develop. You should never, especially in the case with China, you should never say, look at a certain moment and say, this is the state of play. It's very often a development, and you can assess things better when you see it from the development perspective. Yeah.
I would like to take us back to what you said about the neutral dialogue. And you introduced the topic by saying that's what you do with China debate. I'm kind of surprised. I feel that the conclusion was political. And already in 2002, I was on a mission subsidized by the European Commission to introduce a kind of what they call
Well, I think on private law, the decision to establish a fixed private law that was clearly evidently needed for the Chinese. It was a better way for them to write a law than to follow the common law, which was less easy to grasp. And the other reason is China had some experience with Western private law already in the 1930s and in the time of the Republic, where the colonial powers had said to China, if you establish a Western-style legal system, we can do some changes on the exercising our colonial power. So in the time of the Republic, China established civil law on the following the principles of the Swiss civil law and the German civil law. And this, in a way, was an easy way of approach for China, because China had some information through Japan and through Taiwan already. So it was, in a way, in 1978, where you had to start from scratch. It was easy to follow Western law principles. And then with the development, there always came the US as a strong economic power, saying you should follow our laws and you can better do economic, exercise your economic possibilities when you follow our law. So that is a big tension, and that's also a tension that can be seen between the EU and US. There's always been this discussion which law principles to follow. It also worked with China, and I think this discussion is ongoing. So in some fields, China decided, especially in the very modern areas of law, intellectual property, China decided to follow either more the European principles or the US principles. I don't want to dig deeper now into the system. Right, I hope this helped you a little. I think there are the next students standing at the door. Thank you very much for listening attentively, and all the best to you, and good luck.